Have you ever kept a 10 or 20 rupee note lying on the road in your pocket? You must have eaten samosa with that money. If you have done so, you have committed a crime, which can put you behind the bars for almost a year. This law might look absurd to you, but this law is not only one. While India has many such laws which look weird and outdated today, there is a need to either terminate or update the laws. And I am not the alone person who is saying to terminate the laws. This was also promised by our Prime Minister Honorable Shri Narendra Modi in his manifesto during the elections of year 2014 when he came into power. He said, when we pass a new law in the parliament, we should also terminate 10 outdated laws. He has also asked all the union ministers to find 10 such laws from their respective ministry, which are completely outdated, weird and absurd and must be terminated. Well, I thought to discuss with you 5 such laws, out of which some are really serious. There is an utmost need to either terminate the laws or the government must update them. Let's start with a lenient law. The first law is the Aircraft Act of year 1934. Many of you might have flown a kite, but did you apply for a permit? Because according to this act, if you fly a kite, then you must take a permit of flying an aircraft. Now you would be thinking, kite is not an aircraft. According to this law, an aircraft means any machine that can derive support in the atmosphere from reaction of the air, that includes balloons, airships, gliders and flying machines. So if you want to fly a kite legally, then you should take a license to fly a kite. Well, the second law is the Prevention of Cruelty to Animals Act of 1960. In this law, the problem lies with the punishment when this law was enacted. The punishments and fines of the law are not updated with the modern day. The fine mentioned in this law is so less that you would start laughing. An amount of Rs 10 to 50 is charged as fine on first offence, and on the second offence a fine of rupees 25 to 100 is charged, with only 3 months of imprisonment if needed. The punishment under this law must be updated according to the current time and inflation. Now let's look at the third law, whose problem lies in its inexistence. If you marry someone, it would be considered legally when it will be registered in the court. That's why different marriage act is enacted for Hindus, Sikhs, Jain and Christians, like Hindu Marriage Act of 1955, Christian Marriage Act of 1972. Similarly, there are different laws for every religion. Now think, if two people with different religion get married, then there exists a separate law for them, a Special Marriage Act of 1954. But one relationship is missing in all the law, which valid legally. But you cannot register it as a marriage, and that is same-sex marriage. Now, in the year 2018, the Supreme Court of India abrogated Article 377 and considered the same-sex relationship to be legal. But if they want to get married, then there is no law to register such kind of marriage. The fourth act is the Indian Telegraph Act of 1855. Look, when telegraphs were active before our independence, the Britishers wanted to completely control and regulate the infrastructure of telegraph, so that if any freedom movement is going on where communication is involved, the Britishers could control the communication between the freedom fighters. People say that Article 21 of Indian Constitution provides the right to freedom and personal liberty. This law is against this article. That's why this law needs an amendment. The fifth act is the Sarais Act of 1867. Sarais means hotels, which provide accommodation to the people. This law was enacted to maintain and regulate the conditions of hotel. The section 7(2) of this act, 2 things are written. First, it is mandatory for the hotels to provide drinking to all human, even animals, whether anyone is staying in the hotel or not. And it also allows the citizens to use the toilet of any hotel and the hotel cannot deny anyone for this. There is one big issue with this law, that providing drinking water and toilet is the duty of government. If the hotel is a private property, then how could it be allowed to use for the public? So the debates between public and private properties can be used to amend this act, which is being suggested for a very long time.